free to ask. All right, so I had a few issues on estate planning, okay? Intestacy. Okay, most people in the U.S. don't have a will. Great majority, like 60% or more, don't have wills. And if you don't have a will, who gets your money when you die? It passes in accordance with the intestacy statute to those people in the statute. I mean, there's just so many people who don't have a will. The legislature eventually passed a law so you wouldn't have these fights with the various family members. So now there's a priority, you know, and there's a statute that tells you who gets what and what percentage and in what order. And if certain people have passed away, who gets it then? It's all laid out in the statute, and I cited the statute in the slide. So you're basically, everybody has a will that was covered by the legislature in the intestacy statute. But if you want to make sure that the people you want to get your estate, and you want to make sure they get it in the amounts that you want, you're going to have to prepare a last will and testament. And it's binding on the court, it's binding on everyone, as long as it's proved. You know, that's when you go down and probate a will, you're proving the will is valid, that the person signed it, and they did it in front of witnesses and a notary, and it's their signature, and this is how their estate is going to go. So basically it directs who's going to get the assets upon death, and it appoints an executor, and you can appoint guardians for minor children, and you can set up trusts for people who may need it. All kinds of people who have children who are not able to handle their financial affairs for various reasons. You can put money in a trust to make sure that your child is taken care of. They don't have access to the money right off. And you can also plan your estate so you don't have to pay much in estate taxes, or can reduce it at least. So this is something that a lot of people don't know. I found over the years. So the will is called the will governs the probate estate. That is assets in your sole name. Like you have a bank account and only your name is on it. When you pass away, the will is going to control where it is. But there's many kinds of non-probate assets. Contract asset, joint ownership assets. For example, if you and I have a bank account and it's in two names, and you say in your will everything to my beloved spouse, it doesn't make any difference. I get it. If you pass away first and I'm the joint owner, I get it. And if I pass away first, you get it. That's the way it works. So your will controls some of your assets, but not all of them. So if you want to make sure that the people who you love and who you want to get your estate actually do get it, you have to look at all these different, the way that these non-probate assets are set up. For example, IRAs. Now you could say, my daughter Sally gets my IRA and my son gets the house. Great. So your son, if the house is in your sole name, your son will get the house. But the IRA passes in accordance with beneficiary designation. And if you designated your estate, let's say, as the beneficiary of the IRA, your daughter doesn't get the IRA. It goes to your estate and gets split up as set forth in the will. Or if you say, this was a case we had one time. The mother said in the will, everything to my 5 sons in equal shares. But she had 5 different accounts with different amounts in it, and she had put the names of the 5 different sons on the different accounts. So even though it looked like from her will that she wanted everybody to get an equal share, there was no probate estate that passed under the will, because all the accounts were jointly held assets. So when she died, whoever's name was on the bank account took that account. And some had several $100,000, and one had $50,000, and another one had $40,000. So everybody was very upset. I mean, not the people that got hundreds of thousands, but the people who didn't get much were suing the other brothers, saying, hey, mom wanted us to have it equally.
So if your spouse and you have a home together, on both names on
the deed.
Yeah, and you have one child, but you have a blended family, like 2 other children. How does that go?
Okay, so if you have a blended family
Yeah.
and you have one child, and you and your spouse own the house,
I-
so whoever dies last will determine who gets the house. For example, let's say you and your spouse have one child, and your spouse had other children from another marriage.
No,
Or-
no,
No,
no.
okay.
It's children, not marriage.
Oh, okay. So whatever happens, let's say if you pass away first and your spouse lists just one child in his will, that child will get the house. If he lists all 3, then they split the house. But you have a jointly held asset. The survivor gets everything. So he would get the whole house. Or if he died first, you get the whole house. And whatever's in your will control where it goes next. Okay? All right. Okay, so this I put in to show you, what's happened. These are all these past years and what is the exemption? Now this is just federal estate taxes. And what's the estate tax rate? So I mean, the exemption has gone very high. So, it's over $5 million. So you'd have to have an estate that exceeded $5 million before you paid any federal estate taxes, right? But then we have New Jersey estate tax. New Jersey has 2 death taxes. It has an estate tax and it has an inheritance tax. The estate tax is paid based on the size of the estate. So for estates that are above $675,000, that's a house, and most of the house, if you have houses and a couple $100,000, you're going to exceed the exemption. You have to pay a New Jersey estate tax. Then there's an additional tax. It's for people who leave money to outside the direct bloodline. Like if you leave money to a parent, a grandparent, children, grandchildren, you don't pay any inheritance tax. But if you leave money to nieces, nephews, friends, anybody outside the direct bloodline, there's an inheritance tax to pay. And those are the percentages that you have to pay. Okay? Okay, so gift taxes. So everybody knows, right, that the annual gift tax exclusion, you can give $14,000 per person per year. So if you have 3 children and you want to make gifts to them, but you don't want to have to file any gift tax return, you just limit it to $14,000 to each one, $14,000 or less. And you can make a gift, and you don't have to report it anywhere, and just write them a check. And the same thing, if you're married, your spouse can write the check too for $14,000 to the same kids, because you can make gifts of $14,000 to any person in 1 year with no tax return due. And if you give more than that, then you have to at least file a gift tax return. And New Jersey doesn't have any gift tax. So the only thing you'd be paying, if you had to pay anything, would be on the federal gift tax return. Okay? And this portability is just something that came into the law very recently, the last revision of the estate tax law, where you used to have to set up trusts to make sure that people shared the exemptions. Now you don't have to do that anymore. You don't need trusts under your will. Everybody has a $5 million, over a $5 million exemption. And if somebody doesn't have a trust, you can still elect it on a federal estate tax return. Life insurance, it's a great way build up the size of your estate. If you can buy life insurance and then leave it to the children, you can also put the life insurance policy in the trust, and it's not taxable if you put it in the trust. If you own a life insurance policy, when you die, you have to pay estate tax on it. But if you, that's why a lot of people will set up a trust and put the life insurance in the trust. Because if you survive the transfer of the policy by 3 years, no estate tax to be paid. And then, you know, I just put this up. There's all kind of trusts you can set up. Some people don't want to leave money to just their children. They want to set up a big dynasty trust. They want to put money in to a trust and then let the kids have some of the money, the grandkids, great-grandchildren. And then if you put it into a trust, it doesn't get taxed. It gets taxed once, just on your death. After that, it's there for anybody to use, and you never have to tax it again. Okay, so that covers estate planning, and I'm going to cover like planning for long-term care. Okay, any questions about estate planning? Okay.